How did their one little mistake turn into a full-blown legal battle with lawyers on both sides? I never thought one ordinary Monday morning would catapult me into the kind of chaos I had only heard about in cautionary tales. Yet there I was, standing outside a small courtroom in Jackson County, my palms sweaty and my mind racing. My attorney, Melissa Jackson, a tall, poised woman with an unwavering gaze, was rifling through stacks of papers, scanning them with a determination that mirrored my own desperation. Across the hallway, I glimpsed Michael Dorsey, someone I once considered a mere acquaintance, but now he was the adversary in a legal war that seemed to have spiraled out of control. I remembered waking up that morning feeling like everything was just fine, maybe even great. I had gone for a quick jog around my neighborhood, typical suburban scenery with neat lawns and white fences, then hopped in the shower and thought, what could possibly go wrong? I had a decent job, a circle of friends, and a comfortable routine. That sense of normalcy now felt almost absurd as I shifted my weight from one foot to the other in that narrow corridor, waiting to walk into a hearing that would determine if my entire life was about to flip upside down. It started so simply. I can pinpoint the exact moment. 3 months ago, in my cluttered living room, I was sitting at my old wooden desk, laptop open, half watching some rerun on TV while I skimmed through emails from work. I worked then, still do, theoretically, for a mid-sized tech consulting firm called Ridgeline Solutions. I specialized in client relations. Nothing too fancy, mostly making sure our clients got the right proposals, updated contracts, and timely reports. It was the kind of job I could do on autopilot most days. I was so used to routine that I barely registered the significance of a certain email until it was far too late. I recall the email subject line, URGENTPLEASEREVIEW. It came from one of our vendors, an electronics supplier called Eastbridge Devices, run by a man named Alan Gray. Eastbridge had been providing some specialized components we needed for an IT infrastructure project. The job was high stakes, at least for me, because I was trying to prove my worth to my boss, Mr. Lawton. He was always big on client satisfaction and efficiency, his two mantras that he repeated more often than he said hello. That morning, I got the email from Alan. Just a short contract addendum for more components, a slight tweak to shipping terms. In the hustle of that day, I was behind on a few other tasks. I saw that subject line and thought, sure, another piece of paperwork. I'll handle it quickly. Sometimes, that's all it takes. A handle-it-quickly mindset. One hasty reading, one missed line, and you sign. I had done it dozens of times. This was no different, or so I believed. The addendum had a small table with shipping costs and dates, something about a new route, new packaging requirements. I only glanced at the terms, trusting it was the same boilerplate language we always used with Eastbridge. I didn't notice an entire clause inserted halfway down the page, something about a liability shift if the shipments were late, and a mandatory acceptance on our side of potential surcharges. I clicked to sign digitally, typed my name with a flourish, and emailed it back to Alan with a polite, all set, thanks. I felt a momentary sense of accomplishment. I had closed yet another task, right on schedule. Little did I realize that in my rush, I had just made an unapproved guarantee on behalf of Ridgeline Solutions, one that would cost us an enormous sum if the shipments arrived behind schedule. No one else had reviewed it. No one else even knew that final version existed. It was the ultimate unspoken rule in our company to check all contract changes with the legal department. But that day, I broke that rule. I was confident. I was rushed. I wanted to impress my boss. So I did the unthinkable. I signed an unvetted legal document. Life went on as usual for a few weeks. We had staff meetings, phone calls with our usual corporate clients, and even a small office party celebrating a recent success. I barely remembered that contract at all. Then, about 2 weeks after I signed, the shipments started arriving behind schedule. It was a perfect storm. A strike at one of the ports on the West Coast, unexpected storms that grounded flights in the Midwest, and a shortage of drivers for the trucking company that Eastbridge used. So every single piece of equipment we needed was delayed by days, sometimes even weeks. One morning, I walked into Mr. Lawton's office as he slammed a folder onto his desk. His tie was crooked, and a vein pulsed visibly at his temple. He tossed the folder in my direction. Ethan, do you have any idea what's going on with Eastbridge? We're getting hammered with client complaints. And Alan Gray is quoting some weird penalty clause we supposedly agreed to. Something about a late shipment surcharge. Did you okay that? My mind blanked. I had no recollection of a penalty clause. I remember signing an addendum about shipping, I replied, trying to keep my voice steady. There was some mention of surcharges, but I didn't think it was a big deal. It was standard, right? Lawton practically roared at. Standard? Our contract never included punitive surcharges for delays caused by them. You mean you signed something that shifted liability onto us if they can't deliver on time? The rest of that day was a blur. Emails flew between our accounting department, the legal department, and Eastbridge. At first, Eastbridge insisted the clause was standard across all their revised contracts. Our legal team demanded to see the version I signed. When they pulled it up, it had my digital signature right under a line that said, "We agreed to cover any penalty fees in the event of delayed transport, regardless of who caused the delay." I felt my stomach turn cold. I wanted to argue that I hadn't noticed that line, or maybe it had been inserted after I signed. But it was embedded in the PDF with a timestamp that matched the moment I typed my name. My meltdown had just begun. We tried to negotiate quietly. I went on phone calls with Alan Gray, trying to reason with him. We had known each other for a year, so I expected a little goodwill. But he was under pressure himself. Apparently the delays were costing Eastbridge a fortune, so they were passing the cost along to us. A contract is a contract, Alan argued. Ethan, he said, I'm sorry if you didn't see the clause, but you did sign it. We're all struggling with these shipping nightmares, but that's precisely why we updated the terms. We can't shoulder all the costs alone. His tone was calm but unyielding. Meanwhile, Mr. Lawton was furious. Our legal department scolded me for skipping the review process. At first, it seemed we could handle it internally, pay some fines, or maybe push back with a countersuit that the contract was signed under incomplete disclosure. Our corporate lawyers debated whether we had enough evidence to claim it was an accidental signature. But a contract, especially with my name and our company's legal backing, is no trivial matter. The more we tried to twist out of it, the more Eastbridge insisted on the legality of every single word. Word got out to our major clients that we were stuck dealing with late shipments and might pass costs on to them. They started withdrawing or threatening to break deals with us. Tensions rose. At one point, Eastbridge's counsel sent a formal notice that they intended to seek damages if we refused to pay the penalty. The sum was staggering, hundreds of thousands of dollars. Even though we were a mid-sized firm, that was still a huge chunk of money. If we absorbed that cost outright, we could face layoffs or a serious budget crisis. So the wheels of legal warfare started to turn. I was naive enough to think it might end there. A series of legal letters, an ugly settlement, and maybe a final handshake. But everything I touched seemed to crumble. As soon as the penalty fiasco went public in industry circles, an old competitor, Baxter Tech, swooped in. They offered to pick up the slack for some of our clients if we couldn't deliver on time. Our biggest contract threatened to jump ship. Lawton nearly burst a blood vessel when he found out. "This is a disaster," he hissed, looking at me as though I were personally responsible for sinking our entire operation. Legally speaking, the question became whether that clause was truly enforceable or if Eastbridge had manipulated the wording. Our lawyers argued it was unconscionable, that it placed an undue burden on us. Eastbridge's lawyers countered that we had accepted it with full knowledge. Tensions escalated. Accusations of fraud got tossed around. Ridiculously large figures danced in our email threads, like potential damages that soared into 7 digits if our biggest clients sued us for failing to deliver. It felt surreal. I wasn't just a name on a piece of paper. I was the scapegoat, the cause, the man whose small oversight might topple an entire chain of business relationships. My personal life suffered too. I was staying at the office until midnight, searching for any earlier emails or phone transcripts that would prove we never intended to assume such heavy liability. My girlfriend at the time, Claire, tried to be supportive, but as the weeks dragged on, I withdrew from her. My phone buzzed incessantly with urgent messages from colleagues, and even when I managed to crawl into bed, my mind raced with doomsday scenarios. I started missing meals, skipping workouts. Everyone around me either pointed fingers or tried to calm me down with bland reassurances. Claire eventually asked if I could step away from the project, but it wasn't that kind of situation. I was too deeply involved. I was the living center of the storm. About a month into this corporate meltdown, the final blow came. Eastbridge officially filed a lawsuit against Ridgeline Solutions. They claimed breach of contract and demanded immediate payment of the surcharges. Our legal department responded with a countersuit, alleging that Eastbridge had misrepresented shipping timelines and forced an unfair contract condition. Meanwhile, a few of our important clients threatened to sue us for not meeting delivery deadlines. The entire fiasco turned into a tangle of legal disputes, with me at ground zero. When I first stepped into that law firm's conference room, where we held preliminary settlement talks, I tried to maintain a confident front. Yet I could barely concentrate. 2 attorneys from Eastbridge, both in immaculate suits and perfectly polished shoes, presented a mountain of documents highlighting every reason we owed them. Melissa, my attorney, tried to pick apart their arguments. My boss, Mr. Lawton, sat to my left, arms folded. He rarely spoke, except to glare at me whenever Eastbridge mentioned my signature. I felt like I was pinned under a spotlight for something that started as a passing email. A series of depositions followed. I had to provide sworn statements, recall exactly how and when I reviewed that addendum. Each question made me tremble inside. I kept thinking, why didn't I just forward it to legal like I was supposed to? Over and over, I had to see my digital signature on that cursed PDF. Eastbridge's lawyers questioned my competence, my diligence, even my honesty. I tried to keep calm, but my anger rose. I wanted to point fingers at them, to say they snuck the clause in. But deep down, I knew I had no proof. It was entirely possible it was there all along, in black and white, while I breezed through it. Somewhere in the midst of that, I began losing friendships. People looked at me differently, as though I were a liability. One colleague, Bethany, who'd always been friendly, whispered one day near the water cooler, "Ethan, you really messed up. Do you think they'll fire you for this?" I didn't have an answer. Another coworker, Derek, was convinced that if we just apologized and paid a smaller settlement, we could salvage the relationship with Eastbridge. He didn't grasp that we were well beyond an apology. The leadership at Eastbridge felt betrayed, as though we had tried to slip out of paying, so they doubled down. Our top management felt cornered and refused to give an inch. In that environment, any sign of weakness was like blood in the water. The fight escalated with each passing day. Court dates were set, depositions expanded. I spent more time in conference rooms with lawyers than I spent in my own apartment. My desk at home piled up with neglected bills and unwashed coffee cups. Claire told me she couldn't handle the constant tension in our conversations. One night we argued and I yelled at her for not understanding how dire the situation was. She left the room in tears. I sat awake afterward, staring at the living room wall, feeling like a man whose life was unraveling one thread at a time. And that is how I found myself in that cramped hallway outside a county court. The day of the preliminary hearing arrived in an almost cinematic fashion. The air felt thick, as if charged with unspoken grudges. On the benches lining the hallway, I saw a few of my coworkers, including Derek, flipping through notes on a tablet. Alan Gray from Eastbridge stood near the windows, talking quietly with his two attorneys. My heart drummed so loudly I thought others might hear it. This was it, the moment that would determine if the lawsuit would proceed to a massive trial or if the judge would push both parties to settle. When the bailiff called our case, we filed in. Long tables, harsh fluorescent lighting, a judge perched behind a high wooden bench. The tension was suffocating. Our attorney gave an opening statement. Eastbridge's attorney responded. They argued that we accepted the shipping liability in writing, that it wasn't forced on us. We claimed it was unconscionable, that I had no authority to sign such an amendment on behalf of the entire company. The judge listened with an inscrutable expression, occasionally scribbling notes. I glanced around the room. Lawton sat close by, his jaw set. Across from us, Alan Gray watched impassively. He barely looked in my direction, as if I were just another business nuisance. I remembered how once, after a successful project, Alan and I had gone out for a celebratory dinner, joking about the future of the tech industry. How had we gone from that to this? One stroke of my keyboard, one reckless moment, and here we were, locked in a feud that threatened both of our companies. As the hearing proceeded, I felt the spotlight on me again. Eastbridge's attorney hammered away at the chain of emails I had exchanged with Alan. They read them aloud, including my casual sign-off. "Looks fine to me. Let's finalize ASAP." The subtext was clear. I had personally green-lighted the new terms. Melissa tried to direct the conversation toward the idea that the clause was hidden, that Eastbridge exploited my haste. But the judge wanted tangible proof, not just theories. Ultimately, the judge set a trial date, instructing both sides to consider alternative dispute resolution. We spilled out into the hallway, no closer to resolution, but with our entire schedule consumed by preparations for a trial that could drag on for months. News of our legal battle spread. Articles appeared in local business journals. Online forums speculated that Ridgeline Solutions was failing. Some claimed Eastbridge was morally bankrupt. Others pinned the blame on me, though they never mentioned my name publicly. Just an anonymous mid-level employee who messed up. Still, it stung to see it discussed so openly. Meanwhile, the weight on my shoulders grew. My father called me one evening after seeing a snippet on a local news site. "Ethan," he said in a concerned tone, "is everything okay? I heard rumors that your job's in trouble." I tried to reassure him, but I had no real comfort to offer. "We're working through it," I said, which was code for, "I have no idea if I'll still have a job in a month." Time became a blur of depositions, mediation attempts, and tense negotiation sessions. Each side refused to budge much, so the mediator sessions always ended in frustration. There was a distinct moment during a late-night strategy meeting at our law firm's headquarters When I realized just how deep into this nightmare I was, Melissa was laying out the possible scenarios. Best case, we settle for a few $100,000 in damages. Worst case, we lose in trial and pay triple that, plus legal fees. Either scenario spelled doom for our department's budget. I asked her, what if the judge finds me personally liable? Her face softened. That's unlikely in a corporate contract dispute, she replied. But we can't dismiss the possibility of them naming you in the lawsuit if they suspect negligence or misrepresentation on your part. Negligence or misrepresentation. The words rattled around in my mind. I had never intended to misrepresent anything. I was just too rushed, too careless. Yet in the eyes of the law, good intentions carry no real weight. The system demands evidence, procedure, and adherence to written agreements. My personal feelings, my regret, none of that mattered once I'd placed my name on that document. My relationship with Claire grew more distant. We had shouting matches that ended with one of us storming out of the apartment. I overheard her telling a friend on the phone that she felt like I was slipping away. My entire identity seemed consumed by the lawsuit. I even started to resent her for not understanding how high the stakes were. In truth, I barely understood it myself. I was stumbling from one crisis call to another, half living in the backseat of taxis and rummaging through file boxes at my attorney's office until midnight. Meanwhile, the rest of my life crumbled. I missed birthdays, family gatherings, even doctor's appointments. Nothing mattered except finding a way out of this legal quagmire. Then came a new development. Eastbridge discovered internal emails that suggested we had some knowledge of shipping delays before the contract was finalized. They tried to paint it as a malicious act on our part, like we signed anyway, intending to cheat them out of rightful compensation. Our side insisted those emails had been taken out of context. The tension escalated further, and the possibility of settling seemed more remote than ever. There was talk of a jury trial, of corporate reputations on the line, of catastrophic financial consequences. Each new piece of evidence added more drama, more potential for disaster. I started experiencing panic attacks. My heart would race unpredictably, especially late at night. Sometimes I'd jerk awake gasping for air, convinced I was about to be crushed under a mountain of lawsuit paper. I was no hero, no suave operator who thrived under pressure. I was just a regular guy, an office employee who had once believed that as long as you followed the steps, life would treat you fairly. That notion was gone. Instead, every day felt like a fight for survival. Shortly before the main trial date, we underwent a final mediation attempt. We gathered in a neutral conference center, both teams accompanied by mediators. Mr. Lawton himself showed up, along with two other executives from Ridgeline. Eastbridge brought Alan Gray, his CFO, and their legal counsel. For almost 10 hours, the mediator bounced between the two conference rooms, hearing each side's arguments, numbers, offers, and demands. We hovered around the phone, waiting for each update. Every so often, the mediator would say something like, Eastbridge insists on X amount for settlement, otherwise they proceed to trial, or Ridgeline won't consider paying more than Y, and they also demand certain disclaimers. By the end of that excruciating day, no agreement was reached. I remember walking out into the parking lot, the late evening sky streaked with reds and oranges, feeling completely hollow. It dawned on me that I might be locked in litigation for months, possibly years. No part of my life felt safe. Claire met me in the lot to pick me up. My car had broken down earlier that week, a final insult in a long line of humiliations, and I collapsed into the passenger seat, burying my face in my hands. She didn't say anything. Neither did I. Silence had become our default. The trial date arrived as a chilly morning in mid-December. I wore a black suit, the same one I'd worn to a friend's wedding once upon a time. That day, it felt like funeral attire. I could scarcely believe I was about to stand in front of a judge and possibly a jury to defend a signature I'd scribbled without a second thought. The courthouse halls smelled of stale coffee and old paper, the kind of institutional odor that seeps into your clothes. Inside the courtroom, tension was palpable. Prospective jurors filled rows of benches. The judge, a somber-looking man with silver hair, explained how the trial would proceed. Our attorneys delivered opening statements, painting Eastbridge as unscrupulous for slipping in an unexpected clause. Eastbridge's attorneys countered that we had every opportunity to read the contract. The words due diligence got tossed around frequently. My name came up in nearly every sentence. The attorneys from Eastbridge hammered away at the idea that I, individually, had recklessly bound Ridgeline to a disastrous turn. They insisted that if I had missed the clause, that was my fault, not Eastbridge's. Witness after witness took the stand. Lawton testified about company policy for contract reviews, how employees are meant to get legal clearance, how my signature alone normally wouldn't be enough, yet I had a level of responsibility in client relations. Next, Eastbridge brought in their contract manager, who explained how they always forward changes in a highlight format, expecting the recipient to read them. I cringed each time my name arose, each time the term oversight or negligence was mentioned. It felt like my entire professional life was on trial, my every mistake dissected under a microscope. Alan Gray testified too, explaining how Eastbridge had to implement these surcharges due to external shipping fiascos. He claimed they never intended to trap us, that they simply inserted the clause to protect themselves and expected we'd carefully review it. As I listened, memories of simpler times with Alan flooded me. We'd once shared laughter over beers. Now we faced each other like sworn enemies, orchestrating competing narratives in court. During cross-examination, our lawyers tried to cast doubt on Eastbridge's practices, highlighting how quickly they moved from negotiation to lawsuit. Yet Eastbridge simply maintained it was business, not personal. When I finally took the stand, I felt my shirt cling uncomfortably to my back. My pulse thundered. Melissa guided me through a series of questions: my role at Ridgeline, the volume of contracts I typically handled, how pressed for time I was on that particular day. I admitted that I usually flagged changes for legal to review, but I had missed it. Then came Eastbridge's attorneys. They picked apart each statement, zeroing in on any discrepancy. "Isn't it true you responded to that email saying, 'Everything looks fine, let's finalize'? Was that not your signature on the PDF, indicating you had read and agreed to the changes? Had your supervisors told you that your signature alone could not finalize legal terms, or did you assume you had the authority?" The worst part was I couldn't lie. Any hint of dishonesty would backfire, so I answered truthfully, acknowledging my mistakes, trying to emphasize the clause was hidden or at least not adequately communicated. But Eastbridge's lawyer made me read my own words aloud from the email thread, and it was damning. I had effectively told them, "Yes, this is fine," in plain language. There was no mention of needing approval from legal, no caveat or condition, just my naive confidence. We trudged through days of testimony, arguments, and procedural matters. The judge kept a firm hand on scheduling. Every evening I left that courtroom drained, returning home to an empty apartment because Claire had temporarily moved out, saying she needed space from the constant legal drama. I'd sit on the couch, reading depositions or statements, occasionally staring into nothingness, wondering if life would ever go back to normal. Sometimes I scrolled through old photos on my phone. Before the lawsuit, before I had heard the words penalty clause, I saw pictures of me smiling at a barbecue or giving a goofy thumbs up with coworkers. It felt like a foreign existence. Closing arguments were a crescendo of accusations and pleas. Our side argued that Eastbridge's contract manipulations were fundamentally unfair, that my single oversight didn't justify massive damages. Eastbridge argued that the law must uphold signature, or all business deals would collapse into chaos. They claimed they lost money from shipping mishaps that should rightly be Ridgeline's burden under the contract. When the lawyers finished, the judge dismissed the jury to deliberate on certain counts, though corporate suits often involve partial verdicts or negotiated points. The tension was excruciating. After hours of waiting, the jury delivered a mixed result. They found that while Eastbridge's surcharges were high, the clause itself was valid because I had knowingly signed. Ridgeline was liable for a portion of the damages, though not the full amount Eastbridge demanded. Each side saw it as a partial victory, a partial defeat. But the war didn't end there. Subsequent hearings would be needed to set final damage amounts and handle the side suits from our clients. The attorneys on both sides exchanged cold handshakes. There was no real closure, just a step in a never-ending legal marathon. In the days that followed, I expected to be fired. Mr. Lawton called me into his office for a private meeting. I walked in, bracing for the worst. He asked me to close the door, then told me to sit down. His expression was unreadable. "Look," he said, "I can't sugarcoat this. You cost the company a lot of money. People are furious. Our reputation took a serious hit. But I also know this was a confluence of bad luck. Shipping strikes, storms, the whole 9 yards. I'm not blind to that." I nodded, saying nothing. "Corporate wants your head, Ethan," he continued bluntly. "They want someone to blame. But I've argued that you've suffered enough, personally and professionally. I'm giving you a chance to stay, but in a different capacity. And you'd better follow protocol to the letter from now on. Understood?" My eyes stung with relief and shame. "Yes, sir," I managed, fighting back tears. "Thank you." I'd avoided unemployment, but my sense of belonging was gone. Office whispers continued. Some coworkers treated me with pity, others with disdain. I threw myself into my new tasks, a far cry from the client-facing role I once held. I had to rebuild trust, and it felt like starting from scratch. Meanwhile, the attorneys hammered out final settlement details with Eastbridge. Ridgeline had to pay a hefty sum, but far less than the initial monstrous claim. We also lost a few clients to Baxter Tech, a blow that would take years to recover from. Alan Gray and I never spoke directly again. We let the lawyers handle it all, like bitter exes who couldn't stand to be in the same room. Claire returned to gather her things a couple of weeks later. We talked quietly in the kitchen. She said she needed some time apart, that I had changed, grown distant, let the stress of the lawsuit consume me. I wanted to argue, to say I was just fighting for my livelihood. But the truth was I had indeed become someone else. My eyes looked hollow in the mirror, my laughter had vanished. We parted on civil terms, though it felt final. I was left alone, with a half-empty apartment and the memory of a better life. In the months that followed, the final checks were written to East and official court documents were filed that marked the dispute as resolved, at least on paper. People asked if I felt relief now that it was over. Honestly, I felt mostly numb. The settlement was done, but the ghost of my mistake lingered. I still had sleepless nights replaying that moment I hit sign on my laptop. I'd think about how quickly a single oversight could turn your entire reality upside down. Nothing was truly the same at Ridgeline. We cut staff to recoup losses. Departments merged. The entire atmosphere changed from optimistic to defensive. I felt like the employee with a scarlet letter pinned to his chest. The cautionary tale. Sometimes my father asked if I was coping. I tried to fake confidence, telling him I'd be fine. Yet I couldn't shake the memory of that quiet corridor outside the court, hearing the shuffle of lawyers' footsteps. That moment had etched itself into my psyche. I decided I needed a change, something to break the grip of fear and regret that clung to me. So I started looking for smaller consulting firms or startups where I could reestablish myself, maybe find a fresh start. I interviewed at a couple of places, always bracing for the question, so why did you leave your previous position? The best I could do was spin a sanitized version of events without divulging the full fiasco. I worried any potential new employer would see me as a ticking time bomb. Yet, ironically, some smaller companies appreciated that I'd experienced a high-stakes legal conflict. One founder told me, "If you survived that, you must have learned some valuable lessons." He was right, if nothing else. I learned respect for details, caution in every step, and the sobering reality that the line between routine tasks and corporate catastrophe can be dangerously thin. Months turned to a year. By then, I'd left Ridgeline. I found a modest position at a startup that specialized in niche software solutions. It was a pay cut, but I felt lighter, free to redefine myself. I gradually regained some emotional balance. The nights of panic attacks grew less frequent. I worked diligently, triple-checking any contract or agreement, determined never to repeat my earlier mistake. Meanwhile, I heard through the grapevine that Eastbridge was facing new shipping woes, but at least I wasn't entangled in that drama anymore. My life became quieter, simpler. Yet sometimes, on restless nights, I'd open my laptop and reread the court documents from the case. Each line seemed etched with the memory of fear, heartbreak, and an agonizing sense of responsibility. I'd close the files, shut my eyes, and remind myself that the past doesn't own me unless I let it. The legal war might have ended, but the scars remained. A permanent testament to how fragile success can be and how one oversight can trigger a chain reaction of unstoppable consequences. Looking back now, I see that the one little mistake wasn't just about failing to read a contract thoroughly. It was about my casual sense of invulnerability, my assumption that the system would protect me if I was basically a good guy. The truth is, the world doesn't owe anyone a safety net. Businesses care about risk, liability, and profit. Contracts are the currency of trust, spelled out in black and white. And if you don't pay attention, if you skip a single line that matters, the fallout can be enormous. I can't say I'm grateful for the experience because it cost me too much. Relationships, peace of mind, professional standing. But I survived. That counts for something. I often think about emailing Alan Gray, just to see if there's any lingering animosity. But maybe it's best to let sleeping dogs lie. The memory of those courtroom encounters and the days of depositions is enough to remind me that some doors shouldn't be reopened. Sometimes I imagine how differently life would have turned out if I had taken 2 extra minutes, just 2 minutes, to carefully read that contract. If I had flagged it for legal review, we might have caught the surcharge clause and renegotiated. Maybe there would have been no lawsuits, no heartbreak, no meltdown. But regrets are a fruitless endeavor. All I can do is move forward, carrying the lesson like a scar. Small mistakes can grow into monstrous storms if they land in the right or wrong environment. And that's how it happened. That's how my one little mistake ballooned into a full-blown legal war with attorneys on both sides digging in their heels, entire companies locked in battle, and my personal life shattered in the crossfire. People love to say it's just business, but to me it was never just business. It was my life, my name on those documents, my shoulders bearing the weight of each dreadful hearing. Even as I rebuild my life, I can still recall the echo of the judge's gavel and the tightness in my chest each time I stepped into that courthouse. I've learned, in the hardest way possible, that no one is immune to the consequences of a careless moment. Some mistakes cost you a little embarrassment or an apology. Others cost you everything but your breath. Mine fell somewhere in between, leaving me battered but still standing. And at least, I'm here to tell the story, to warn anyone who believes that a quick glance and a hurried signature can't possibly upend their world. Because trust me, it absolutely can.